Welcome to U.S. Immigration TV and thank you for watching. In this video, I will discuss the Child Status Protection Act, or CSPA. It deals with children who age out of a petition or turn 21 years of age. It is very complicated, and I know it can be very frustrating to people as to whether or not their children are eligible for benefits under the Child Status Protection Act. So let's break it down. There are two main sections of the Child Status Protection Act. One is when a U.S. citizen petitions his or her minor child, and the second part is when a family member petitions their child or employment-based cases. Let's first take U.S. citizens. That's very simple. It is where a U.S. citizen files a petition for their minor child before the child's 21st birthday. That's it. A child can be under 21, or let's say, for example, the child is under 21 and married but gets divorced or terminates their marriage before the 21st birthday. Or an immigrant petitions their child and naturalizes before the child's 21st birthday. So all of those combinations of a U.S. citizen parent and a child under 21 years of age. Now we move to the second and more complicated section of the Child Status Protection Act. That is all the other family-based petitions as well as employment-based. There are two basic steps for eligibility under the Child Status Protection Act for those type of petitions. One is a mathematical computation, and the second part is the child must seek to acquire a visa within 1 year. The mathematical computation is that you take the processing time of the underlying petition from the time it is filed until the time it is approved. How long did that take? 1 month, 1 year, 2 years? The next part is that you wait until the priority date is current, and then you say, well, how old is the child when the priority date is current? Let's say, for example, if they're 22 years old, and it took 2 years for that petition to have been approved, you can subtract that processing time from the child's age at the time the priority date is current. Now, one of the biggest mistakes I see with people when they are dealing with the Child Status Protection Act is they focus on the age of the child when the petition was filed. That has no bearing on the child's eligibility. What is important is the age of the child when the priority date becomes current, and you subtract the processing time of the petition. If the child's age comes out to be under 21, they could potentially qualify under the Child Status Protection Act. The second step is they must pursue their visa or seek to acquire their visa within 1 year of when the priority date became current, and that's another area where a lot of people mess up and they skip that step, and it results in the child not being eligible. I understand that this is a very complicated immigration benefit. It is very, very confusing. And that's why I say that if anybody has any questions or you believe that your child could be eligible, I would strongly recommend that you seek the advice of an attorney. Or if you have already been denied the visa because, let's say, the U.S. Embassy or USCIS said the child was not eligible, also see an attorney. Maybe there was some misunderstanding or miscalculation, and the attorney could possibly assist in seeking reconsideration. I know I've done that many times in my office where the U.S. Embassy had said the child was not eligible under the Child Status Protection Act, and fortunately, we were able to convince the U.S. Embassy the child was eligible. Now, I'm not making any guarantees in your case because attorneys cannot guarantee results, but if you think your child could be eligible, you should see an attorney. I hope you found this video informative, and if you like this, make sure, of course, to like, share, and most important, click the red box and subscribe. I'm Michael Gurfinkel, and this is U.S. Immigration TV.